Jefferson County Court at Law Number 2 is back in session. Court is in session with its trial docket. First case is cause number 23CCCR 2522. Case is styled the state of Texas versus Holton Thomas Guidry. Jr. Mr. Guidry is present in court with his attorney Todd LeBlanc. Mr. Guidry, how are you doing? I'm doing fine. Thanks for asking. And Mr. LeBlanc, how are you doing?
Good.
That's good. State is present, Assistant Criminal District Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge. Thank you.
Okay. Now, this case was originally set for a bench trial. Is that correct?
That's correct, Your Honor. And may I speak?
Yes.
Whenever I first requested that this case be set for a bench trial this morning, we had no contact with the complaining witness. The district attorney's office had made efforts through myself and through our investigators to make such contact, and had no success in doing so. But prior to the hearing this afternoon, in fact, minutes before, I have received word that we now have contact with the complaining witness in this case, and I would like the opportunity to speak with that complaining witness before we move forward with trial of this case.
Okay. Now, is the complaining witness, you're going to speak with that complaining witness today? I'm trying to figure out, you said you need time to speak to him. I don't know how much time you need.
I anticipate that Mr. LeBlanc is going to want to try this case, so I would want to speak with her in preparation of trial, Your Honor. And I would ask that this case be reset to a later date to prepare for such trial.
Now, Mr. LeBlanc?
Judge, I understand what he's saying. The only issue I have is, evidently he set it for bench trial, and then they was able to contact her after the fact. Between then, if we could have had bench trial this morning, I guess it would have been gotten different.
I know, but I think, just from my recollection, it was mentioned that he needed to contact the complaining witness. I think you mentioned that they wanted to contact the complaining witness. Is that correct?
Well, I mean, I understand he continued to try to contact her, but I think at the time he asked for bench trial, they wouldn't have any contact with her. I presume they thought she would be uncooperative.
Well, yeah, but you're aware that even with actual bench trial, the bench trial motion has to be in writing. Is that correct? I mean, we don't have no motion in writing.
Yes, sir.
For a bench trial. I mean, it's set for jury trial.
I'm sorry.
I mean, the case is set for a jury trial today, and it's one of the cases that's on the docket. Okay, in this case, let's see. I guess in the pecking order.
It's around the middle, Your Honor.
Yeah. We can maybe go down the docket and see if it's reached.
Well, then I don't know how fair that is. If it's this morning, they announced it's going to be a bench trial, and that's why you could come back for a bench trial, and then the next thing you know, I'm in a jury trial. I don't know how. I'd ask court to reset it, see if maybe it's something we can work out. If she's cooperative, I don't know if that's where.
So you want to, you like
to we're agreed on a reset?
Yeah, that's what I'm saying. You're going to agree on a reset?
Well, Judge, I will if you're telling me I'm going to have to go to trial.
It's set for trial. Okay, I mean.
No.
Yeah, I mean, it was set for trial months ago. I mean, when you came in here this morning, before you even talked to the prosecutor, you came in saying it, knowing that the case was set for trial.
But since this morning, I've been prepared for that other case I have, Judge, so I'm just saying.
Okay, so you have two cases?
Push me to trial off.
Okay, well, I mean, you got two cases on the docket. That other case is, okay. So what you want to do on Guidry? What do you?
Yeah. Well, I want to go through the bench trial, but I'm not doing that.
Yeah.
So.
But bench trial, the state has to agree. I mean, it's the day of trial. Okay.
I understand that.
Yeah. So I'm just gonna leave it on. I'm gonna just leave it on here on this jury for right now.
Okay, Judge.
Okay, we'll come back to it. Y'all just have a seat.
Thank you, Judge.
Okay, now is all of the defendants in with that's on the docket today? Yeah. Let's see, we got Willie Ray Guidry. Let's see what else we have. We have Brianna Cobos. Is that correct?
Yes, sir.
Okay, so, and then we have, Lakeisha Garrett.
Present counsel.
Okay. Then we have, Alton Guidry, we have Matthew
Odeberg.
Constant Hall. Is that correct? Yeah, that's. Oh, you could get at the one of them. Andrew, let me see, you got Matthew Constant Hall. That's Mr. LeBlanc's case. Okay,
Your Honor, Mr. Odeberg is here as well. He was on the docket.
was that the bond fault? What was that?
That was, we're ready on this case.
That wasn't on the, that's not on the trial docket. Oh, okay. Okay. Well, if he has a bond forfeiture, where is it? Okay, Mr. Odeberg, would you come forward? Yes, said on the announcement that. Okay, this is cause number 24 CCCR 1826. Case is styled the state of Texas versus Logan Odeberg. Soderberg, is that your full name?
Yes, sir.
How you doing, Mr. Odeberg? Okay. Mr. Odeberg, you're representing the case by your attorney. Attorney Radcliffe, Attorney Kimmer, how are you doing?
Still doing well, Your
That's good. Now, just for the record, Mr. Odeberg, his case was set at 9 a.m. At about 9 a.m., of course, we had to call the name of Logan Odeberg. He did not appear. And I think the bailiff called his case again this morning before the court went into recess, and he did not answer. And I think when the court went into recess about 12:15 or so, and I saw Mr. Odeberg, he was trying to get in the courtroom at that time. Is that correct, Mr. Odeberg? Okay. Now, state, are you withdrawing your motion for bond forfeiture?
May I ask the reason for absence?
I had work. I had work up to 7.
You work when?
I work at Waffle House. I got up to 7 in the morning.
Okay.
I kind of went to sleep and told was work at the time. I didn't have an alarm set or anything.
Okay.
I overslept.
Okay, but you did appear as soon as you were able.
Yes, sir. As soon as I.
He texted me.
As soon as I got up.
Oh, he did? Okay.
After the
And I
court.
apologize for not having the right T-shirt on. 'Cause I just
Okay.
jumped up.
State would recall the warrant.
Okay, so we're gonna recall the bond forfeiture on Logan Odeberg. And we're gonna reset this case.
Like I just say on the trial, like a trial. We just said for trial.
Give us a date. April 28th. Is that a good day for you?
That's
Okay, this case will reset to April 28th, 2025.
right.
Okay. Now, Mr. Adams and Mr. Gidger. Ms. Adams?
Yes, sir.
Mr. Gidger? Willie Ray? Gidger? This is cause number M 330-398, case of style of state of Texas versus Willie Ray Gidry. Mr. Gidry, again, how are you doing? That's good. And Mr. Gidry, you're represented in your case by your attorney. Attorney like St. Adams, Mr. Adams, again, how are you doing?
Doing well.
Now, before the court went into recess, there was some oral motions that was made by Mr. Adams, and court, after hearing his motion and arguments, the state was requested to make, I think, contact with one of the officers to see if there was a video that exists and some notes that was taken. Is that correct?
Both officers, actually two officers.
Okay.
And the state has in fact reached out to those officers in taking up the issue with the video first. I confirmed with the detective Brian Sayin with the Jefferson County Sheriff's Office that he did not have body worn camera active whenever he was speaking to the defendant on the date subsequent to the offense date.
Judge, that creates another problem. One, I would like additional opportunity to explore it, but even the case under Article 3802 Texas Code of Criminal Procedure, as it relates to taking a statement of a witness, there's a recording requirement.
Right.
So my client sort of, it should be a recording, and it should have been submitted in 2021, but it wasn't. But even with that being the case, I don't think they should be able to use.
Well, they can use it.
Right, because it's not.
I mean, it's a requirement that has to be, those statements has to be recorded.
Right, and Judge, if my client was to testify in this case, then it wouldn't be fair for them to impeach him with something that's not admissible. His statements to.
Well, I don't.
Would be inadmissible because it wasn't recorded. And then the second thing is, Judge, the notes that the police officer had the victim, alleged victim, verify as their statement, that's something Andrew and I can see with our own eyes watching the video, and that wasn't produced in the.
Okay, now let me do this here one at a time. The statement that was not recorded.
My client.
Okay, your client statement that.
They saying it wasn't
Okay.
recorded, but he saw a body cam on.
He can't really speak to whether.
Don't
Well, put it like this here.
And that's why.
If if obviously, you have a right, I'm talking about the defense, to move for evidence to be suppressed prior to trial or during trial.
Correct.
Okay, and so that's one issue. Now, regarding the notes.
Notes, we can see them with your own eyes.
Now, these notes that, well, there's an officer that's supposedly on the video from August the 2nd.
The day of the incident. And
August the 2nd.
Right.
August the 2nd of 2021.
That's the video.
So you're saying that one officer has a body camera on,
Talking to the.
talking to this gentleman,
making notes.
and then another officer is taking
No,
notes, or it's the same officer?
Same officer is taking notes, and then that officer, after he finished taking his notes, is approaching the complainant and saying, "Is this your version of what happened?" And he was writing those notes, and you can see him write the notes on the
Okay.
video. Those notes were not disclosed in discovery, and you can see them.
Okay, so-
You see them.
Hold
I've
on, let's
spoken-
let the state.
I spoke
Yeah,
with
but
the
I'm
law
too-
enforcement officer. He expressed to me that he typically takes notes on calls and then reduces them into his
A report?
report, which Langston does have access to via discovery.
I don't have the notes, and again.
And he says typically he just discards the note.
I mean, it's common practice for officers, for anybody to take notes and then reduce it to a report.
Yeah, but the thing is that it's the difference between saying, here is notes for use of my report versus these notes as being a witness statement of Judge Holmes. And if you look at that, he's talking to the complainant, he's getting the complainant's version of what happens, and then he's offering that as a witness statement of the complainant. So under the rules, I'm entitled, I think 106, I'm entitled to all statements.
But
of
I
the
think
complainant.
according to what the state is saying, based on the conversation that the state had with the officer, those notes are no longer in exist because they was discarded. Those notes were just used to make a report or to make his witness statement. So you're saying that they have a statement from him?
No, on the date of the incident.
I know, but
The statement they got from him is what he's saying is not on a body cam being recorded.
no, but let me ask you something. You're saying they got his version, they talked to him.
They talked to him, and that's
Okay.
in a police report.
Okay. It's in the police report. We're talking about the first video. Was that recorded?
No, the first video does not have my client at all. The first video only shows the complainant, the lady who's saying that she was the victim. That's the video of that, and he's taking.
He's taking notes of the
On
complaint.
the complainant, and he's asking the complainant, basically, this is what your version of what happened. That's on October, on the 2nd. On the 11th is when the next officer comes out.
Oh, well, let me do this.
Wearing the body.
Let me do this here.
We don't have that.
Okay.
But and then he gets my client.
Listen, okay. When the officer is asking the complainant questions, can you hear the questions and can you hear the answers on the tape?
We had some difficulty with that. It wasn't perfect. Andrew can speak to it. When I watched it, it was muffled to me. So what he got on writing could be missing from what you can actually hear. But Andrew watched it. He can speak to it.
In
It wasn't
addition to that,
perfectly
you
clear.
also have her own statement.
Hmm?
In addition to that, you also have her own statement.
But the bottom line is that I should be able to impeach her with that particular statement. And what I'm saying is that his notes would be better. You watch the video just like I would. I'll listen to it. Some of it is muffled. So I'm at a disadvantage.
So the tape is muffled?
I disagree with that characterization.
I think so.
So if he's taking notes, he's asking the questions and it's already recorded.
Could you hear clearly everything we were listening at? I know I couldn't.
Well,
So what I'm saying is that his notes would be to my advantage for what I could not clearly hear. And what I'm saying, Judge, is this: if the state is proffering to you that those notes of what the complainant said are being destroyed, then would I not be entitled to the exfoliation instructions? Specifically, those was in the province of the state. He had no access to them, neither did I. And that officer, and I'm not blaming Andrew. Andrew has no fault for that. I'm not blaming him. But what I'm saying is that the officer who destroyed them, then now they're at an advantage. And the advantage that they're at is that those particular statements that I could use to cross-examine, I no longer have. So now what I would ask
you no longer have them on paper, but you have them on the video.
But due to the quality of the sound, I really don't have it on video. So what I'm saying is that as a remedy for me, because their officer destroyed those notes, I'm asking you to order that officer not be allowed to testify at all. You see what I'm saying? Because before we, and that's another reason why I would ask for another continuance of the case today is to explore that as well with my client. But when he and I was listening to it, it wasn't clear as to what the lady was saying. So now I'm at a disadvantage. And because I'm at that disadvantage under due process, if I'm forced to go to trial, I'm asking you to disallow the state from calling that officer.
Well, good.
I was going to say that we could also, before that officer testifies, play the tape, Your Honor, outside the presence of the jury, if that would satisfy the court.
Mm-hmm. We could, okay. We got two issues. The bottom line is, let's cut to the chase.
I don't want to go to jail.
That's right. That's the bottom line. You're not ready for trial. That's
Not
what you're
today.
saying.
Correct.
Okay. Well,
And I gave you reason. And he.
I understand that, but I understand that. But I told you this case was set number one. It was set number one months ago when we reset the case,
Right.
right? This the oldest case on the court's document. Okay. What I'm saying is you should have knew about this here way back
And it's been on the trial docket for much
for a
longer
while,
than that.
right? And you just basically bringing this up as an issue today. Let me ask you this here.
But, and I want to
Let-
remind Court of one thing too, just before you say, I also want to remind Judge, and this is in the file too, the state had filed a motion for a continuance.
On the last
that-
time?
That was granted, and this, you see, that's their motion, I'm looking at it.
Okay.
That's their motion of continuance. So what I'm saying is considering
When was that?
they have filed one, I have not filed one.
Okay,
And that's, so
Okay.
I would think just
okay.
the equity
Okay,
of the
okay, I
situation.
understand, I
And I'm
understand.
showing it to you, that's it.
Normally, the court does grant at least one continuance for each side.
And they got theirs, and this is it right here in writing.
Right.
I'm looking at it,
Now, if you,
so I'm asking
Okay.
for mine.
okay, let me do this here. Let me just take that advisement for.
I'm
and we'll-
showing it to you, Judge.
Okay, I
They already
understand, I
got
understand.
theirs.
Okay,
That's it right here.
all right, just have a seat.
I would state for the court that the defense has announced ready this morning.
I understand,
No,
I
I said
understand.
subject to some things.
Okay, understand. Okay, y'all just have a seat.
Thank you, Your Honor.
Okay, now, Mr. Dahl, Brianna Denise Cobos,
Yes, sir.
so y'all still ready on her case?
We're still ready, Judge.
Okay, next, okay, Ms. Cobos, you could, have a seat. All right, Mr. Dahl, let's see, who else we have? Right, Mr. Kimler? Lakeisha Deanna Garrett? Y'all still ready? Okay. Okay, Alton, we got him sitting on hold. Okay, where's Mr. LeBlanc on his other class?
Stepped out to speak with his defendant.
Oh,
Your Honor.
to Matthew Hall?
Yes, Your Honor.
Okay. Let me. do this. Mr. LeBlanc,
Yes, Your Honor.
on, Matthew Constant Hall,
He's right. Your Honor.
okay, who's the prosecutor? Ms. Simmons
We're ready on that one.
and Mr.,
One moment, Judge.
okay, I'll hold. Okay, this is cause number 24 CCCR 1994. Matthew Constant Hall.
Yes,
Okay, Mr. Hall, how are you doing?
no, fine, sir, so.
I'm doing fine, thanks for asking. Mr. Hall, you're represented by Mr. LeBlanc. And Mr. LeBlanc, what is your announcement?
Judge, I'd originally announced ready. I think we had this worked out. It's a matter of how lenient the prosecutor's gonna be, but I gotta get some information regarding a disability again. And it's
If I may, Your Honor, the defense counsel has told me that there might be mitigating evidence in regards to his mental health that the state would be willing to take into consideration. We just can't do so without having that documentation before us. He does seem to think that regardless of that information, we should be able to set it for a plea and dispose of the case at that time.
what I was saying.
Okay, so how much time?
A week, Judge, I mean,
1 week?
that'd be fine.
Okay. We're gonna reset this one, 1 week. This is Matthew Constant Hall. Yeah. Is that 17? He's in, he's not in. Okay, yeah, that's the lady from, yeah, okay. Okay, we're gonna reset your case, Mr. Hall, for 1 week.
Yes, sir.
Gonna get your reset from our court coordinator. Once you get your reset, you're free to go. And you have a blessed day.
Thank you.
Okay. Okay, so we're back to Mr. Willie Ray Gidry, Mr. Hubel,
Yes, Your Honor.
and Mr. Adams. Mr. Adams is requesting a continuance. As far as continuance, you have any objections?
Obviously, if it being a number one setting and the fact that the state has its witnesses ready, I would object to the continuance.
Judge, he asked for one, I gave him one, and it's in writing. So I
Okay,
think
let me-
that's only fair.
Okay, yeah, let me do
And
this.
he asked for it and he got it. And I didn't have one problem when he would ask for this, and I showed it to you in writing. So now for him to have a problem, my thing is, what's good for the goose should be good for the gander, and I showed you what he got his.
Yeah. So, let me do this. How soon could you be ready?
Not today or tomorrow. Yeah, I
Okay,
mean-
well, we can set you next week.
Well, no, I know it can't do next week because I'm in trial for certain in Orange on a termination case in Mandy Rogers. Now, maybe if you want to do the following week, but that week I got a termination in Mandy Rogers because that should be the 18th, right? And then Monday.
17.
Yeah, the 17th,
If
18th.
she the 18, we got you first.
Hey, yeah, yeah. Well, that's a big, I mean, they've been years getting ready for this
Yeah.
termination. If you give it 2 weeks, so yeah, I
This
can.
case is 4 years old.
Yeah, we.
But I, 2 weeks, how about two, I mean, 2 weeks, if you give me 2 weeks.
Hold on, hold on a minute. Let me
But
do
next
this.
week, I
Oh, I can't see it. Can I see it? She's right there. Isn't she on there? On that side. To your right. She's right there at the edge, right there. She right there. I can see her good from here. Yeah. Oh, let me try it again. Hold on,
It's me, I'm fine.
let me move this over. Hold on, let me. If I can. Right there. Okay. Well, we couldn't, Mr. Dahl was blocking, well. He was being blocked a little bit. Let me move the other camera.
You leave that.
No, you moved out the way.
She don't want to. That's fine. Oh, they're probably sitting over there.
Hold back.
There it is. Oh, whatever you just did.
What about right here?
Mhm.
Okay, we can see that. Okay. Nicholas Nardini,
Yes.
I'll come up to that first row, all the way, chair all the way on the end. No, behind the wall. You're gonna, Mr. Swallow? You're gonna sit next to Mr. Lunardini?
Yep.
And Mr. Alman, you're gonna sit next to Mr. Swallow. Castillo, you're gonna sit next to Mr. Alman. John Zeno? Mr. Zeno? You're gonna sit next to Miss Castillo. And Wheaton is gonna sit next to Mr. Zeno. Munoz, you're gonna sit in that first chair in this section right there, yes. And Traeger, you're gonna sit next to Mr. Munoz. Mr. Franks, sit next to Mr. Traeger. Coleman,
Yes.
move your hat, and you're gonna sit next to Mr. Franks. Right there, and sit next to him. Mr. Smith, you're gonna sit next to Mr. Coleman. Mr. Tamaz, you're gonna sit next to Mr. Smith. And Zach, you're gonna sit next to Ms. Tamaz. Cavazos, Cavazos,
Yes, sir.
all the way down to the end, that second section. You're gonna sit in that first chair,
All right.
all the way at the end, and you're gonna sit next to Miss Pate, you're gonna sit next to him. Miss Brown, okay, Miss Hunt. You're gonna walk down there, there's a chair in between you and Miss Pate. Doctor, Miss Lisa Doctor, you're gonna sit next to Miss Hunt, just follow her. And Resnikoff, you're gonna sit next to Miss Doctor. All the way down. All the way, yeah. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm presiding judge here in County Court at Law number 2. You have been asked to come to court today to serve as a juror in a criminal case that we have in County Court at Law number 2. The criminal case is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. In County Court at Law, we handle misdemeanor cases. The district court handle the felony cases. Now, your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted. Now, you will be examined for inclusion on this criminal jury. Our courtroom hours are normally from 9 to 5. However, in the County Court at Law number 2, we set our trials in the afternoon because we have a large docket in the morning, and a lot of times we're in court usually past 12 noon. And so therefore we have our trial in the afternoon starting at 1:30. Now, whether you're selected as a juror in this case or not, you're performing a significant service which only free people can perform. Now, this case will be tried expeditiously, consistent with justice, which require a careful and impartial and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate at recess, at meals, and at night. Now, at this time, I must administer to you the first of 2 oaths. So at this time, I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service and qualifications as a juror, so help you God?
I do.
Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you may be considered as a juror in this case. Also, there are certain excuses and exemptions that some of you may wish to claim. First, I will determine if all of you possess the qualifications to serve as a juror in this criminal case. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover that fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and given a fine up to $500. Now, the way I'm going to ask the question, I will ask a series of questions. I do not want you to answer those questions out loud. Just answer those questions to yourself. And then once I ask the last question, I will then ask you, is anyone disqualified under the law? First question. Except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question I must ask because it's required by law. I'm not trying to pry into your personal affairs. I'm just trying to obey the law that we judges have to obey. Now, this next question states, are you presently insane or have you been declared insane by any mental health or judicial official? Next question, are you 18 years of age or older? Are you a resident of Texas and a resident of Jefferson County, Texas? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? And that was the last question. Now, is there anyone who feel that they are disqualified under the law? If you think that you're disqualified, just please raise your right hand. Okay. Let the record reflect that no one on the panel raised their hand. So at this point, all members of the panel are qualified. Next, I will now determine if any of you otherwise qualified to serve as a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If these apply to you, but you still desire to be considered as a juror, just continue to remain seated. First question, now I will ask these questions in the same manner that I asked the last series of questions. I was asking series. I do not want you to answer them out loud, just answer them to yourself. And then once I get to the last question, I will then ask you, is there anyone here who would like to claim one of the exemptions? First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12? And jury service would necessitate leaving a child or children without adequate supervision. Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period before today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Or you're a member of United States military forces serving on active duty and deployed away from Jefferson County? Is there anyone on the panel who will be claiming an exemption? Let the record reflect that no one on the panel is claiming an exemption. We will now move to excuses. And the way I will handle the excuses, I will not ask a series of questions. I will make 3 statements. And if you think that any of these statements apply to you and you would like to claim an excuse, just please raise your right hand and we'll ask that you will come forward so we can discuss the matter more privately. And when I use the term more privately, I have a noise sound device that I will turn on. I'll turn off the YouTube and I will turn off the microphone so that no one outside the attorneys or the court and the court reporter will be able to hear you. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the state and the consent of the defense. And this is the last statement. a juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse. No one is claiming an exemptions, and all members of the panel are qualified. Let the record also reflect that the time now is 2:30 p.m. on today's date of March 10th of 2025. State, are you ready?
State's ready, Your Honor.
Defense, are you ready? Okay. Now, we're gonna let the record show that the court has convened in this case. And the case is cause number 23CC Sierra 0842. And the case is styled the state of Texas versus Brianna Denise Cobos. Ms. Cobos is present with a attorney. The state is present with assistant criminal district attorneys, and all members of the panel of the jury is now present. The defendant, Ms. Cobos, as I mentioned to you earlier, is represented by attorney Peter Dahl. The state is represented by assistant criminal district attorneys, attorney Haley Simmons, who's sitting first chair, attorney Andrew Hubel, sitting second chair, and we have attorney Shane Hilton, who is in the jury box. Our court reporter is Ms. Kim Broussard. She will be taking down everything being said, so speak up when you are answering or being asked questions. Our bailiff is Mr. Pickens. You met him earlier. Now, the defendants in this case stands charged with driving while intoxicated. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear this particular case. If at any time you prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. State, are you ready? And defense? Okay. Now, Ms. Simmons, the panel is yours, and Ms. Simmons, 30 minutes be enough? Okay, I'll keep time.
Good afternoon. I'd like to start off with this question, but by a raise of hands, who's actually excited to be here today? Thank you. Okay, we got more. Number 15, your number 9, Rager? How do I pronounce your last name? Cavazos, is that correct?
That is
Okay.
correct.
Well, I'm happy y'all are excited to be here. Everybody else, I hope that changed as we get to talking, okay? So we're here, myself, I'm representing the state of Texas. My name is Haley Simmons. Does anybody know myself or my colleague, co-counsel Andrew Hubel? Colleague Shane Hilton? Does anybody, by show of hands, know the defendant Brianna Cobos or her attorney Peter Doyle? Does anybody know Judge Holmes? You here? Okay. That's not gonna affect any way of you being fair and impartial, is it?
No, I didn't know.
You know his name? Okay. And I saw him back here. You know Judge Holmes as well? Okay. Not first time. Y'all are queuing on YouTube, is that how y'all know?
Yeah.
Okay. Okay, well, welcome to CCL too. So what we're here for today is driving while intoxicated. I'm gonna read a little bit of this aloud. I know sometimes it's hard for everybody to see. A person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. Kind of break it down there on elemental purposes. My job as the state and my burden is to prove each and every element beyond a reasonable doubt. So what does intoxicated mean? That looks like a lot. I promise I'm gonna break it down for you. Not having a normal use of mental or physical faculties by the reason of introduction of alcohol or any other controlled substance, a drug, dangerous drug, a combination of both. And then you look at that bullet point B, having an alcohol concentration of 0.08 or more. So what we're really looking at is having the loss of normal use of mental faculties or physical faculties or an alcohol concentration of 0.08 or more. Does anyone here think that I need to prove all three? I see you kind of, well, you don't think I need to prove all three? Okay, so my burden here is, of course, to prove the intoxication of the defendant, but I'm only required to prove one of those three. So my question, I'm gonna pick on everybody today, or at least I'm gonna try to, starting with juror number 1, Nicholas. And I ask that you speak up when I talk to you. We do have the court reporter here. What's the defendant be drunk? Lucky winner there. Does not have to be drunk. We're looking at intoxicated as forms of loss of physical faculties, loss of mental faculties, and of course we get to the 0.08 BAC or higher. Must the defendant be intoxicated? Juror number 2. We kind of broke that down.
No.
Must be intoxicated. Has to be intoxicated. My burden, if I fail to prove my burden of intoxication, I have failed my burden entirely. So when I come up here and I am alleging that this person has committed a offense intoxicated while operating a motor vehicle in a public place, I must prove one of those three that we talked about. Does everybody understand that? I know I break it down. Why do we have 3 definitions for intoxication? We kind of already talked about this. I got ahead of myself. I'm sorry, I like to talk when I get up here, guys. But I'm gonna break it down for you. Who here has seen Revenge of the Nerds? Y'all like that movie? Yeah? You seem excited about it. Do we know Lewis and Ogre? No? Okay. We're gonna compare Lewis and Ogre today in court today, okay? I know y'all are laughing. So let's start with Lewis. Kind of small, I'm gonna read it out for you. Lewis here is 145 pounds. He has never had a drop of alcohol a day in his life up until his wedding day. He's had 2 glasses of champagne. His speech is slurred. He's got poor balance. He's wobbly. Inappropriate comments. But his BAC is under 0.08. Does anybody here, show of hands, believe that Lewis is not intoxicated? Even though his BAC is under 0.08?
He's slurred.
So what are those things?
His physical.
It's mental and physical faculties. So raise a hand so that we said that. Who here believes Lewis is in fact intoxicated? Show of hands. Juror number 2, you seem a little at odds with that. Mr. Swaller?
Lightweight.
He's a lightweight? Very well, maybe. We've all heard the term tolerance, is that right? Maybe Lewis's tolerance hasn't quite got up there. But he's never drank a day in his life, right?
Yes.
But he's intoxicated by meaning of the definition, is he not? And we see that by the loss of his physical faculties, poor balance, mental faculties, all of the such. So we're looking at all 3. We want to look at all 3, not just one. And if you're selected as a juror in this case, you'll get to sit right here, hear the evidence before you, and you'll get to make those determinations, okay? Ogre. Who here knows Ogre if you've seen the movie? Okay. I'm gonna keep moving down the list. Have I picked on you, juror number 3? Is it Jonathan? I'm gonna read these out, okay? Ogre weighs 250 pounds. He is a champion drinker. He's been drinking since he started shaving at the young age of 16 years old. He drinks 2 to 3 pitchers by himself. He doesn't even slur or stumble. Very high tolerance. There's that tolerance where we talked about. Normal use of mental and physical faculties, but his BAC is over 0.08. Is over intoxicated by meaning of the definition? Who here says yes? Raise your hands. And Jonathan, you're saying yes? I saw juror number, sometimes I gotta count, juror number 6, Ms. Wheaton, you said no. You don't think he's intoxicated? Both? Okay. Well, we're looking at intoxicated by meaning of the definition when we are in here, okay? And I know it gets kind of confusing, I'm going back and forth, and I'm trying my best to help you out here, but if for some reason you're not understanding, just ask me. But we're gonna point to these 2 last key points. Normal use of mental and physical faculties, but the BAC is over 0.08. So we're looking at those 3, we talked about the mental and physical and the blood. He's got normal use of mental and physical faculties, but his blood is over 0.08. So does that kind of help explain as to why? We get ahead of ourselves every time up here, guys. But we're gonna ask, for purposes of both, is Lewis or Ogre intoxicated by definition of the law? Is it either or does it, who feels it's both? Everybody feels that it's both? Is there anyone that feels that maybe Lewis isn't drunk, or I'm sorry, intoxicated, or maybe Ogre is not intoxicated? We can all see the combination of the 3 elements of intoxication. Both. And we talked about this, everybody understands that I only need to prove 1. Whether it be mental, physical, or the BAC is greater than 0.08. Now, if you're selected as a juror and you go back into deliberation, and you're having a hard time as to whether it's mental or physical or blood, you don't have to agree as to that. You all just have to agree as to intoxication. Does everybody understand that? Is anybody confused by that? All good? Who's ever been around someone that's intoxicated? Everybody? Juror number 5, you've never been around somebody that's intoxicated?
I can't kill it, yeah.
You stay out of trouble. Is that what it is? Okay. So you don't, never been around. Juror number 4, let me ask you, is it Ms. Castillo? Okay, you said you've been around somebody that's been intoxicated. What were some of the signs? What did you see that made you make that clarification?
The way that they act, their physical, just the way that they're standing, the way that they always say that whenever someone's drunk, they start asking like, hey, are you okay, or are you drunk, or, just different things,
So maybe by their demeanor or how they're talking or how they're acting. Juror number 5, I'm gonna take your word, you've never been around someone intoxicated. I'm gonna skip to you, Ms. Wheaton. I know I picked on you a little bit. How can you tell if someone's intoxicated? Or what are some of the signs you're looking at?
For me, I notice when they totally are out of character from what usually when I'm around somebody that's like that and somebody I know. And I see totally different characteristics, like how they act, how they talk, what to do, outrageous things, it's just that whole mood.
So you bring up a good point. You say around somebody you know.
Yeah,
When I come to you, juror number, skipping 7, juror number 8, Mr. Martinez? If it's somebody you don't know when you're making a determination and you're looking at things, do you think you'd be able to tell if someone's intoxicated?
It depends on the circumstance.
On the circumstances? So if you don't know somebody, but you're watching their demeanor, you're watching their behavior, is it possible you might be able to tell that they've been under the influence of some substance?
There could be signs that could lead me to that conclusion.
Okay, are you talking about the signs we talked about here?
Yes.
The balance, acting out of character, which in
Yeah.
this case, we probably wouldn't know how their normal character is, right? But again, selected as a juror, you're gonna see evidence, you're gonna hear evidence, you're gonna get to see those things, and it is for y'all to make that determination, okay? So we talked about it, smell, action, kind of like the demeanor you're talking about, balance, wobbly on their feet, can't stand up straight, speech slurred, maybe incoherent, can't form a sentence. Judgment, they're making bad judgment calls. Who here knows someone who has been arrested for DWI? Okay. I'm gonna circle the number, don't keep those hands raised. Juror number 9, juror number 10, juror number 12. No, juror number 11. Is it Mr. Smith?
Yeah.
Okay, I got you, 12. Ms. Tama, am I saying that correctly? The minutes, okay. 13, juror number 15, juror number 18, no, 19. The Ms. Doctor?
Yes.
It's hard to count sometimes, I'm really short, guys, I'll have to work with me, okay? And juror number 20. We can kind of go down the list here. So y'all all know somebody that has been arrested for DWI. Given that information, would any of those that just raised their hands, would that affect your ability to be fair and impartial in this case? By show of hands, is there anybody that feel that they would not be able to be fair and impartial? Everybody here would be able to make a determination on the facts for this case alone. Okay, good. Who here knows somebody who has been hurt, injured, or worse by the actions of an intoxicated driver?
Oh, I got one for you.
Yes, and that's juror number 5. Mr. Dino?
What?
Which one? This one?
No, the one that you just.
Okay, so
We started this with.
who here knows someone who has been hurt, injured, or worse?
Yeah.
The one prior.
Before you start that.
Okay, who knows someone that's been arrested? Okay,
Not the rest of them, I like to elaborate on it.
you'd like to what? I'm sorry.
Elaborate on it.
Okay, yeah, you want to speak on it.
I need to speak, yeah.
You need to speak. Okay, you want to speak outside the presence. We can absolutely do that and call you back in. Okay, not a problem. And that's your number 5, which is Nino. I'm gonna remember your name. Okay, we'll come back to you. We're gonna go back to that next one. Who here knows someone who has been hurt, injured, or worse by the actions of an intoxicated driver? Anybody on the first row? Juror number 1. Juror number 15. Juror number 16. Am I missing anybody? Okay. Juror number 1, is that something you would care to elaborate about, or is it something you would rather talk about? I mean, presence of just the judge alone.
I can, it was work related, going to a job site in Louisiana where the intoxicated person crossed the line. It's 2-way traffic, 2-lane highway, and they slammed into some people I know at our work, so.
Well, first and foremost, I'm very sorry to hear about that. Has that affected your, let's say we're here on a DWI trial today, if you're a slip as a juror, would that affect your ability to be impartial or fair? You'd be able to separate yourself from that and look to the facts of the case before us. Juror number 15, you had your hand raised, right? Okay, would you care to elaborate on that, or is that something you'd like to speak with separately?
No, my best friend was murdered by a gang member at his house who was intoxicated.
I'm very sorry to hear about that. How recent was that?
Ooh, it was about maybe 20 years ago.
It's something that still affects you?
Oh, yeah.
So knowing that and the fact that that man was intoxicated at the time that he committed this crime, and we're here before going to DWI, would that affect your ability to be fair and impartial?
Yes, you have to be fair, but it wouldn't affect the ability because, you know, depending on the facts of the case.
Okay, so we can separate those two. And I know, I'm sorry, sometimes these questions are really hard, right? Your number 16, I saw your hand raised, Ms. Dodd.
I just remembered I do have something good.
You do?
I was trying to think, and I was like,
Okay, that's
I
fine.
remember now.
Let me take care of Ms. Pate, and I'm gonna come to you, okay? Ms. Pate, is that something you care to elaborate about?
Sure, my, best friend and her mother were killed by a drunk driver.
I'm so sorry to hear that. Is that something that was recent as well?
No, that's quite a few years ago, but
Was it here in the county? Okay. Knowing that, the fact that the driver was intoxicated at the time, is that something that you'd be able to separate and equal the facts of this case? And you'd be able to be fair and impartial? Thank you. Juror number 19, Ms. Doctor, I'm kind of
Yeah, a friend from church was in Galveston and somebody was driving on the wrong side of the road. And hit him head on and they permanently messed up their leg. And
So they're permanently disabled,
yeah.
something they have to live with. Would that affect your ability to be here in Marshall? No. Okay. I'm very sorry to hear about that, but I want to kind of point back to this. We're looking at the signs of intoxication and intoxication drivers. I want to make sure that we are all under the understanding that when we're looking at this case, we're just looking at the facts before us and nothing else. Okay. What kind of evidence would everybody like to see in a DWI trial to determine guilt? I'm gonna pick on you, Mr. Traeger. What kind of proof? What kind of proof? What would be deemed proof for you? We were talking about guilt. What would
A lot of times I get like video from the front one.
Video?
From the stop or whatever.
so in-car video,
Something.
body cam, you just wanna see something, right?
Yeah.
Something that can show that I'm gonna meet my burden. Everybody wants to see something, right? Okay, juror number 10. Mr. Franks, what would you like to see?
Same thing, evidence.
Evidence?
Is there?
Okay, so you want to hear from the officer, maybe witnesses, you want to see dash cam, body cam? Does anybody want to see the VAC results? Okay, who all wants to see those things? Blood test, okay. Absolutely, in-car video, body cam, blood test, breath test, I kind of want to go into this one. How do y'all feel about the reliability of these? Does anybody feel that it would be difficult to have somebody come testify as to maybe the breathalyzer and toxicalizer if one is there, or maybe the blood results? Would you be able to take into account testimony as to how those things work and find that it is a reliable device? Juror number 19, Ms. Doctor.
Yeah, breathalyzers are kind of, you know, I mean, you take a shot of cough syrup and he would show you drunk.
Okay, so you might have some difficulty in terms of a breathalyzer. Does anybody else think they have difficulty with that? Juror number 12, Mr. Smith. Okay, so we're talking about just a breathalyzer or an toxicalizer. Are y'all just gonna have difficulty with that alone, or y'all have difficulty with the blood test? Not with the blood test?
I think the blood test is meant like, they can deny it and then, like, feel like I don't wanna take a blood test until I get to the hospital, but at that point, you're all probably goes down, so.
So there are
If
things
it's
that,
like then not.
Yeah,
Or things that happen.
Under legal limit, there's no.
Okay. Do you feel that if someone is giving breath, you wouldn't be able to find that the results of that were accurate by any means?
In combination with other stuff.
In combination, and when you say in combination, we're talking about the other two, the mental and the physical, right? The mental and physical faculties, the lack thereof.
Video or something.
Okay. I'm gonna come to you, I promise, okay? Juror number 12, Mr. Smith. With the breath test, if it was just that, would you be able to go off that alone? Or would you still be able to take into consideration possibly the lack of mental or
There would have to be
other factors?
Yeah.
Okay. Juror number 15.
As I was saying, it would be contributing other factors besides just blood and, breath test,
Okay.
functioning skills and whatnot.
So 15, 19, and 12, y'all would absolutely take into consideration a breath test with hesitancy, but you would keep in mind there might be other factors to suggest intoxication. Am I correct? Am I correct in saying that? Okay, thank you. Testimony and types of witnesses. These are kind of witnesses that may come. We have eyewitnesses, police officers, experts. Okay, well, everybody understand if someone were to come and testify right here, the answers that they provide are considered evidence. Does anybody feel like they hold I'm sorry, I thought I heard something. Anybody here feel like they would hold a higher standard to an officer testifying or a lower standard? Does everybody understand that regardless of who's testifying, you're all starting at the same level of credibility? Right on point? Is that what
Yep.
you're waiting for?
Everybody's the same.
Everybody's the same. You are to not hold anybody with higher regard or lower regard. But what I will say is this, you determine credibility. There's things you get to look at when a witness is testifying. Maybe the way they talk, the way they're acting, answering questions. You will determine how you feel the witness is credible. But I ask that you understand that when they first take the stand, they're all starting with that same credibility. We can all understand that. And we've talked about this, trying to catch up to y'all here. The legal limit in the state of Texas is 0.08. At the point we reach 0.08 or higher, we're looking at intoxication. Everyone is impaired in their ability to operate a motor vehicle. And I know this is a silly question. Does everybody know what a motor vehicle is? Okay, I know it sounds silly, but that is part of the element. Operating a motor vehicle in a public place. Everybody knows what a public place would be? Okay, everybody understands those two things? All right, let's talk about burden. We're gonna talk about in terms of the defendant. Does the defendant have a burden? Yes, doctor, you said no. That's correct. Who has a burden? That's correct. We have a burden. I have to meet my burden beyond a reasonable doubt as to every single element. Okay? Subpoena powers. The defendant has the right to subpoena. They have the right to discovery. They have the right to trial. They have the right not to testify. And with that, I kind of want to key in here. I always ask, a defendant exercising a right not to testify, would anybody in here hold that against them? Good. You are not to. And they have the right to defenses. Does everybody understand the rights that the defendant may have? Or does have, I'm sorry, whether they choose to exercise them? You are not to hold against a defendant their right not to testify. Presumption of innocence. Everybody has it. Show of hands. Who believes that the defendant sitting right here in this chair is guilty? You're good. I'll just raise your hands. I saw you thinking. You're like, wait a minute. I have to meet my burden, right? Like, we can't jump ahead. We are here for trial, and it is my burden to meet every single element. And at that point, you as jurors, if you're selected, you will go back to deliberate in a little jury room, and you will make a unanimous agreement as to that. My burden is beyond a reasonable doubt. Does anybody here think I have a definition of that? You do, Ms. Doctor? All right. Forgive me when I say this. We don't. I'm not allowed to give you a definition of beyond a reasonable doubt. I know. So Texas law requires the state prove its case beyond a reasonable doubt. And I know you're saying, please tell me what that is. I cannot. Texas law does not allow us to give you a definition of this term. That's the law. I can't give you one. It's not beyond all doubt. If it's beyond all doubt, you'd probably be sitting right here testifying to what you saw because you'd be a witness. You would have been there. It's not beyond a shadow of a doubt. Who here watches like CSI and all that? Erase it from your mind right here, okay? It's not beyond an unreasonable doubt. Best explained, you will know it when you see it. Trial is made up of puzzle pieces, and it is your job as a juror, if you're selected, to put those pieces together and determine whether or not I get my burden. Does everybody understand that? Does everybody still wish I could give you a definition? Because I can't. Okay? It's really, truly, I know a lot of people hate this term, it's a matter of common sense. The evidence that's given to you, it's for you to make that determination with your common sense. You never check it out before, you bring it in. So jury's duty, I'm almost done talking, guys. Decide the facts, apply the facts to the law, and follow the law. Does anybody have any issue with this standard? Can everybody follow the law? Is there anybody that would have difficulties sitting in judgment of another for maybe personal reasons or religious reasons? All right, any questions for me? No? Well, thank y'all for listening to me talk for the last half hour. If you're selected as a juror in this case, I do look forward to presenting. Thank y'all.
Mr. Gold? You may present. Yes.
What we are doing now, is Fort Hour. It helps with Fort Hour, it gives us list of people. But they're garbled today, because some people are here. All my notes, I'm gone for me. But there are some things that I will talk to y'all about. I have a couple of questions for somebody. In a driving while intoxicated, if they collects, try to introduce evidence, what they call scientific evidence, blood test, stuff like that. Do y'all believe that is there any kind of burden on the defense to produce their own experts? We don't have it. Sure. Nobody? Okay. The defendant is accused of operating a motor vehicle while intoxicated. And the state is going to have, I don't know for sure, but they're going to have some witnesses try to prove that fact to y'all. But they have to prove the fact, and it has to be done on the basis of beyond the reasonable doubt. Now, when I was in law school, I had a professor explain to me what beyond reasonable doubt was. And he said a good working definition of beyond reasonable doubt is a doubt, whether you can articulate it or not, based on a reason, whether it's shared or not, that convinces you of the element that's an issue. So a doubt about reason, doubt based on reason, but about a material fact. It is not a material fact in this case as to whether anybody was wearing a footlocker shirt or suits or tuxedo. Doesn't matter. It is material in this case, is that whether they were driving and operating a motor vehicle in a public place while intoxicated. That's material. So that's what you should look at. And not to go down any kind of rabbit trail, I guess is the word. Anything that distracts you from that. Because those are the ones that matter. I mean, if the guy was on I think George Jones, I don't know, you don't know who George Jones was, but I think he once got arrested for DWI when he was operating a lawnmower, riding lawnmower, and they arrested him with child response chicken. But anyway, they did, and it's a motor, wasn't really a motor vehicle, but fence was it wasn't a motor vehicle. Okay. So you have elements that have to be proven to your satisfaction, even if you can't share it or don't want to share it or don't articulate it to other people. It's what you feel that the evidence shows, and whether or not the state has proven each and every element of the case, which y'all have done. If there's no requirement that we produce experts, because if there is in your mind, the requirement is not. But if it is in your mind, there's nothing we can do because we don't have any. This case was some time back, and that's in the nature of the way the cases go. There's probably 7,000 misdemeanors, I think, every year in Jefferson County. So there's a lot of cases. So it takes a while to get up to the court to go to trial. And then you have a trial document, which there was like, I think 3 or 4 people this morning, and we got chosen. We're here. The characteristics that I think are most important. You know, is whether the person was driving and operating a motor vehicle. It can't be like parked on the side of the road. It can't be parked in their garage or in the driveway. They have to be operating the motor vehicle in a public place. Every day, President of the United States used to like, go driving on his ranch with maybe a couple of beers on it. Which it's not a public place, it's a big old ranch. It's President of the United States, so do what he wants to do. Those are the elements that you have to have, driving and operating. Motor vehicle. Whether the person is responsible. Does anybody have any questions? See any hands, so if there are any questions. I do have a question for you. Your name is Tractor? Traeger? Did I represent your wife in the board? Okay. Make sure it's not doing that. Okay, I hope that again. Okay, somebody, I represented the girl. Any other questions? Thank you.
Okay, ladies and gentlemen, we're gonna ask that you step out into the hallway and follow the bailiff. Now, we may call some of you back in for some follow-up questions. So, now when you come back into the courtroom, after the question, make sure you sit in the same chairs, okay? So you can go out either door, either the door to my right or the left. Okay, you may stand as the jury, as the panel exit the courtroom. Mr. Dahl, your client. Ms. Cobbles, would you please stand as the jury exit the courtroom? Is that door like he locked it? Oh. Hold on a minute. Okay. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 23 CCCR 0842, case style State of Texas versus Brianna Denise Coppos. Let the record reflect that Ms. Coppos is present in the court with her attorney Peter Dahl. Let the record also reflect state is present with Assistant District Attorneys, Attorney Haley Simmons, Attorney Andrew Hubel, and Attorney Shane Hilton. Let the record also reflect that the panel is not present in the courtroom. State, are you ready?
Thanks, Your Honor.
Defense, are you ready?
We're ready, Judge.
Okay. Mr. Pickens, would you please have the panel to come and they can sit where they were sitting earlier? Everyone, please stand as the jury comes in. Panel, y'all can be seated. The panel can be seated. Somebody said- Is that juror number 17? Was that 18? Hunt?
Yes, Your Honor.
Okay, yeah, y'all can be seated. Okay. Okay, let the record reflect that the court is back in session and calls number 23 CCCR 0842. Let the record reflect that the court is in session in the state of Texas versus Brianna Denise Coppos. Ms. Coppos is present with her attorney Peter Dahl. Let the record also reflect that the prosecutors are present. Assistant District Criminal Attorney Haley Simmons, Attorney Andrew Hubel, and Attorney Shane Hilton. Let the record reflect that the panel is now present and seated in the courtroom. Okay, ladies and gentlemen of the panel, Mr. Pickens, could you get some sure badges? You have a bag of tags? You have any tags over there? Yep. Yeah, put 7 of them on the counter. Okay. Now, ladies and gentlemen of the panel, Ms. Brella Jackson is going to call your name. When she calls your name, please proceed to the jury box. There are some name tags that are on the countertop. You can pick up a name tag, have a seat, and you can pin it on you. Okay. At this time, we'll put you in the hand of Ms. Brella Jackson.
Bradley Swallow.
Mr. Swallow, so far, and have a seat in the jury box. You can grab one of those tags.
Priscilla Castillo.
Castillo, you get one of those tags.
Maisha Wheaton.
You can sit anywhere. Ms. Week, you can get one of those tags.
William Trader.
So Trey, you get one of those tags.
Jason Franks.
Franks. Get that tag right there, Mr. Franks.
Ronald Coleman.
The bailiff had the tag for you, Mr. Coleman.
Ramiro Cavazos.
Cavazos, Mr. Cavazos, would you please come forward? Bailiff has the tag for you. Everyone, would you please put your tag on? Okay, ladies and gentlemen of the jury, I must administer to you the second of the two oaths that I previously mentioned. So I need each and every one of you to raise your right hand. And once I finish in administering the oath, please say I do. Do each of you do solemnly swear or affirm that in the case of the state of Texas versus Brianna Denise Cabos, that you will render a true verdict according to the law and the evidence, so help you God. Okay, you may put your hands down. Now, members of the jury, I will give you some instructions. So as members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the way to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there's a legal reason why the testimony or document or object should not be received by you. Sometimes I would simply sustain or overrule the objections. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in and both the state and the defense has rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorney have the right to make a summation of the evidence and to make reasonable deductions from that evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt in any independent investigation on your own. Don't visit the scene involved in the facts of this case. Don't read any reports in the newspaper or TV reports about the case, or even on social media. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The badges that you have, you can take those badges home with you, and please wear those badges when you come back to court, identifying you as a juror in this case. Now, ladies and gentlemen of the panel, those who were not selected to be a juror in this case, first of all, I would like to thank you for your time and attention. Your presence here speaks volumes. I know that you may think that you came down here and wasted your time, but I can assure you did not waste your time, because our law requires that we have a certain number on the panel, and we only could have a limited number that actually sit on the jury. So your presence was very important. I think one of the defense attorneys may have mentioned to you earlier that actually while you were sitting outside waiting to come into the courtroom at 1:30, we were handling business here in the courtroom. So your presence was able to help us move cases. That's the only way we can move cases, because individuals have a right to have their case set for trial. However, on days like today, sometimes they decide when they actually see a jury that they would like to have their case disposed. So you were able to help us to move cases today. Now, I know that when you came to court this afternoon, you probably looked over the top above the door and you saw County Court at Law Number 2, Judge Terrence L. Holmes, and you probably said to yourself, I'm in the right place. This is Judge Holmes' court. Now, this is not my court, this is your court, because I'm only an humble public servant serving the citizens of Jefferson County. And you are the citizens of Jefferson County. I've said that to say this. Anytime that you're in the area of County Court at Law Number 2, Jefferson County, Texas, please feel free to come and have a seat in your courtroom. You can have a seat in the area that you're sitting in behind the wall. We call that the peanut gallery. But it does not mean that you can bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what goes on in Jefferson County. And I will assure you that you'll find it very interesting. Now, you were not selected to serve as jurors on this case, but one day you may serve on another case that is more maybe appropriate for you. Our bailiff, Mr. Pickens, he has some letters. He's going to give each and every one of you a letter. If you need to drop us a line, you can do so. Your jury service is complete. you can leave here and go across the hall to the district clerk's office if you need some type of letter or excuse. They can provide that to you. Now, before you leave, I usually give everyone a handshake. And as I mentioned to jurors in the past, we still have COVID and some other things in our community. And so I can't shake your hand, but I can give everyone what I call an air handshake. So on behalf of everyone in County Court at Law Number 2, I'd like to thank you for being here this afternoon. Your service is complete. And again, anytime you're in the area, please feel free to come and have a seat. And as I mentioned to you earlier, our cases start at 1:30. You can watch us on YouTube, or you can come and sit in the peanut gallery and see what goes on, okay? So at this time, you're excused, and each and every one of you have a blessed day. Okay? Everyone, please stand as the panel exit the courtroom. You're excused. Okay. You may be seated. Now, state, when are you going to put on your case in chief?
We intend to start tomorrow at 1:30.
Start tomorrow at 1:30? Okay. Okay, thanks. Ladies and gentlemen of the jury, this will conclude your jury service today, because the state is going to put on its case in chief on tomorrow, starting at 1:30. As I mentioned to you earlier, we have a lot of cases in the morning. Sometimes it goes to 1 or a little later. But when we finish with all our cases in the morning, and hopefully we'll start at 1:30. And just to give you an idea of what to expect, on tomorrow, the court is going to read the information. The defendant is going to enter a plea, and then the state is going to start off with an opening statement. Then after the opening statement, then the state is going to put on its case in chief. When I say case in chief, they will be calling their witnesses in the case, okay? So again, you'll be excused until tomorrow at 1:30. And when you come tomorrow at 1:30, make sure you have a seat on one of the chairs outside in the hallway and wait for the bailiff to come get you, because we may be handling a matter here in court, okay? So at this time, you are excused. Everyone, please stand as the jury exit the courtroom. Okay, court will be in recess. Prosecutors, y'all can remain. I need Jefferson County Court at Law number 2 is back in session. Court is in session and calls number 24CCCR 1924. Case is styled the state of Texas versus Lorea. Darcy, Ms. Darcy, would you please come forward? Ms. Darcy, your full name is Lorea Darcy? Ms. Darcy, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Darcy, you may put your hand down. How are you doing, Ms. Darcy? Okay, Ms. Darcy, you're represented in your case by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
And Mr. Boudreaux, do you waive a record in Ms. Darcy's case?
Yes, sir.
State is represented in this case by Attorney Andrew Hubel. Attorney Hubel, again, how are you doing?
Still doing well, Judge, thank you.
And Ms. Darcy, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Lorea Darcy, on about June 30th of 2024, while you were in Jefferson County, Texas, that you committed to Class B misdemeanor offense of failed to identify fugitive from justice, refused to give information. Ms. Darcy, do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, no contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. No contest means you're not fighting or contesting the charge. And that's why you're pleading no contest? Okay, Ms. Darcy, I have before me a document that is titled Misdemeanor Plea Admonishment. You recognize this document?
Yes.
On page 2 of this same document, there's a set of initials, LD on the line next to a box that's checking over contingent, which means no contest. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document?
Yes.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled Discovery Certification. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant? Ms. Darcy, before you signed and initialed these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct
Yes.
to the best of your knowledge?
Yes.
Ms. Darcy, are you a citizen of the United States?
Never states one.
Any objections, Mr.
No,
Boudreaux?
sir.
No objection, states exhibit number 1 will be admitted. Mr. Boudreaux, you are advised and counsel. Ms. Darcy, is there any evidence that she is currently mentally incompetent to stand trial?
No, sir.
And Ms. Darcy, your attorney, Mr. Boudreaux, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Ms. Darcy, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is to 5 days jail with credit for 2 days to begin today or before 7 p.m.
Okay, Ms. Darcy, the state is offering that you serve 5 days in Jefferson County Jail. You'll be given credit for the 2 days that you've already served. What is the court cost? The court cost in this case is $277. Are you able to pay the $277 court cost?
No.
Okay, Ms. Darcy, I have before me a document that is titled Jefferson County Affidavit of Indies. I'm handing this document to your attorney and he will hand that document to you. Ms. Darcy, do you recognize that document? And is everything on that document still true and correct today, or I'm talking about your financial situation?
Oh,
Okay, could you you have a pen to make those changes?
I'm like this job ended.
Okay, I understand, but if you're not making an income, you can scratch through where you had the previous amount that you was making of money, and if you're not making it, if you don't have anything, you just put 0. You, I guess you had $2,000 on there, right? On the left hand, on the first page?
Yes. No, it says 18.
No, at the top, oh, not at the top, but on the left-hand side, when they ask you, your income per month, okay, you gotta scratch through that, and if you have an income, you put that there. If you don't, you put 0. Okay, now is everything on that document still true and correct today?
Yes.
Okay. Now, Ms. Okay, so you scratched through the 2,000, is that correct?
Yes.
And so that's 0?
Yes.
Okay. Now, Ms. Darcy, the court is gonna find that you're indigent. Based on the finding of indigency, the $277 court costs will be waived pursuant to Article 42.15 Texas Code of Criminal Procedure. Now, Ms. Darcy, do you understand the state's offer?
Yeah.
And do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Ms. Darcy, this will conclude your case. You're going to have a seat. You're going to call your name. You're going to follow the directions of the bailiff. Once you finish following the directions of the bailiff, you will follow the bailiff. And you have a blessed day. And Mr. Boudreaux, you're free to go. And you have a blessed day.
Thank you, Judge.
You're welcome. All right.
Sorry to make you work so long.
Oh, no, that's not a problem. Okay, this will conclude the calling of the court's trial docket, pre-trial conference docket, and the announcement docket, all 3 dockets on today's date of March 10th, 2025 in County Court at Law number 2, Jefferson County, Texas. Prosecutors, you're excused. Mr. Bruiser, you're also excused. Everyone, please have a blessed day.